This is a presentation that I gave at the Guild of One Name Studies DNA seminar in October 2018. It was one of 3 streams. This was seen as one of the more advanced topics and was not recorded at the event. The beginner stream was recorded. I made the decision that I would record my session at least, and then upload the information to the Guild website and to my YouTube channel. I shared this session with another presenter who may or may not upload their own presentation. So this presentation is only around 15 to 20 minutes in length, and I do have a more detailed presentation available if anyone is interested in hearing it. So my name is Julie Goucher, and if you do have any questions after the event, then you are very welcome to contact me. My email is julie.goucher@one-name.org. So the GDPR came into effect on the 25th of May and was the first significant shift in data protection since 1998. It's regulated by the Information Commission Office, or the ICO. Their website is www.ico.org.uk. The purpose of the regulation is to provide a mechanism that is consistent across Europe and the UK and provides protection for individuals and their data, and is an attempt at providing greater transparency and control where data is saved by organisations and the way that those organisations then subsequently use that information. So the GDPR relates to information about living people only. So for the bulk of genealogists, as long as you are working from yourself back and you are researching in what I would call the traditional manner, you will probably not be too affected by this regulation. That said, if you have information that you send to other people, you need to be getting consent. So by that, that's perhaps writing a newsletter, a Facebook group, using Twitter, uploading pictures, anything of that nature that relates to information about living people, then you need to be getting consent. And as we work through this presentation, which won't be particularly long, we will look at the various elements and what each of those elements mean. This does not relate to people that are now deceased, but it will relate to information such as an obituary, which is obviously about someone who is now deceased, but will typically mention people that are still living. So there are no automatic exemptions. Unlike the 1998 Data Protection Act, the GDPR does not contain any exemptions for those of us who collate information about living individuals when it is connected to a hobby, such as genealogy. That does not mean that everyone needs to register with the ICO, but to effectively self-assess and identify and what I refer to in an in-house manner in what you do with the data that you hold on living people and why you have that data. So there are 2 elements here, a controller and a processor. So what's the difference? A controller is responsible for how and why the data is processed. A processor is responsible for processing the personal data on behalf of the controller. So an example here is that the Guild is the controller of the membership data, and the printer who prints our journal and subsequently sends it out in the post to the membership is the processor. The GDPR applies to the processing of personal data by organisations and individuals within the EU and the UK. And, this is very important, it also applies to those outside of the EU that offer goods and services to individuals who reside in the EU and the UK. So if you live in Australia, New Zealand, Canada, the United States, Mexico, but you hold information on people who reside within the EU or the UK, you need to be gaining consent of that information from people and asking how they want to hear from you, why they should want to hear from you. You get the idea. And that is very important. There is no automatic exemption because we're genealogists. So consent or legitimate interest. So the starting point for organisations or individuals who process data relating to living people is to identify which of the 6 legal bases for processing personal data for each processing task. So everything is evaluated on its own as a single process. So the ICO defined consent as any freely given, specific, informed and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. So that means that tick boxes on forms must not be pre-ticked. They must be, the boxes must be there, so yes, you want to opt in, or no, you do not want to opt in, and the individual must tick the relevant box. That is giving the power back to the individual on whose data you're processing. Consent must be separate from other terms and conditions and should not be a precondition of agreeing to subscribe to a particular service. There should be an active opt-in, which means that there should be no pre-tick boxes, as we've just discussed, that it should be granular, which means it's relevant for each particular task. So organisations and individuals who offer different things should receive or gain consent for each different element of those things that they offer. So an example to that can be joining the Guild of Unnamed Studies. You want to hear from the Guild, yes or no. If you register a study and have that study added into the register, which is published in July, that is a separate action and therefore would require a separate yes or no. So organisations should be able to identify themselves and any third party. You cannot define categories of third parties. So let's use DNA as an example. You can say that I use a third party organisation, Family Tree DNA. You cannot say I'm a third party to a number of DNA organisations. Whilst that may be true, you would need to specify them all individually. Documented. You need to keep records to reflect what individuals have consented to. You should make withdrawing easy and advise people that they have the right to withdraw their consent at any time, and to advise people how they do that. Giving and withdrawing consent should be equally as easy as each other, and there should not be any imbalance in the relationship between a controller and an individual. So legitimate interest is defined by the OCO as where processing is necessary for the purpose of a legitimate interest pursued by the controller or by a third party, except where such interests are overridden by the interests or fundamental rights and the freedoms of the data subject which require protection of personal data, and in particular where the subject data is a child. So that is a significant change from the previous legislation. So in using the Guild as an example to this, is that the Guild had no way of knowing how old people in the membership were. We had no way of knowing whether we had anyone who was defined as a child, and what is the age in which you cease being a child and become an adult. we're a global organisation, and we need to be mindful that the age of consent and the ability to give consent may vary across the countries. So initially, when the Guild first began looking there at the request of consent from the membership, we looked at anyone who was under 16. To reflect the globalness of us as an organisation, we've in fact increased that, so if anyone is actually under the age of 18. But there is no clear-cut structure of what a legitimate interest is. So there may be a mixture of an individual, organisation and third party, and a wider community element or a commercial basis. But you need to have identified all those different elements and assess how and when you're getting control and who is giving the control. And where you have consent or are getting consent from somebody who is a minor, then you need to obtain that consent from a parent or guardian. So how do you assess what information you hold and whether actually is it a legitimate interest? So would someone expect you to use their information in a particular way? And would that way cause harm to somebody? If that is the case, then it is likely their interest overrides yours. So are you undertaking a legitimate interest? And is the processing necessary for that purpose? So on the basis of just regular membership to any organisation, somebody pays a fee to join your organisation, and therefore it is quite reasonable to assume, but you cannot assume, they have to have consented that you use their address in a particular manner. So they would be expecting to hear from you. They might not be necessarily expecting you to publish their details in terms of things like surname interests or a one-name study or into a database of people that have a DNA project, for example. So you do need to go through and consider what you do for each element of your study, and that is really important, that you are able to justify any actions that you do within your study, whether that is a one-name study, a DNA study, or both. So the ICO can impose fines on those breaching the General Data Protection Regulation. They say that fines are the last resort, but it's important to understand that those fines are the responsibility of, in the case of a business, the chief operating officer or the director, and in the case of a charity, then it is the burden of the fine upon the trustees, personally and equally. Fines could be a maximum of 4% of the annual and global turnover, or €20 million, whichever is the greater. So, considerations for genealogists and one-name studies. I mentioned a little earlier about a review process, and that does not necessarily mean a significant piece of work. So identify how many moving parts you have to your research and to your study. Do you have a website? Do you have a newsletter? Do you have a DNA project? Are you part of a surname association or history society? Each of those elements needs to be reviewed and assessed on its own merits. I undertook a review of my one-name study. I also took a review of my DNA project, and I wrote to all the individuals on the 24th of May, asking that they contact me if they did not wish to hear from me in the future. I also created a privacy statement which sits on my website and refers to things like cookies, which will reset every 180 days if you're using a WordPress site, and that type of thing. I think the very key thing here is that should somebody say to you, I no longer wish to hear from you, is that you stop your communication to them. and you need to make that as simple for them as possible. So if they write to you and say, I'd like to keep up to date with your one name study, and they just write an email, they should just be able to write an email back to say, I no longer want to hear about your one name study, and it should be on equal footing. It's also worth considering that each element that you look at is that you must be able to justify what you do. So this is the aims of my study, this is the material I keep, this is where I keep my material, and there is a difference. So if you produce a newsletter and the database for the recipient of your newsletter, if that lives in a USB stick in your desk drawer and never leaves the house, that's great. That's one thing. But if it lives on your computer and your computer does leave the house, then that's something different. Is the file protected? Are you taking due care and due diligence to protect other people's information? And as long as you can show you're justified in what you do, the ICO will be happy. The one thing I will also say is that your assessment, your risk assessment of how you keep your material and what material you keep should be a living, working document. So I would say that you need to review that probably yearly, and that's not going to be a significant amount of time spent. I reviewed my processes. It took me about 20 minutes. I wrote a privacy statement, and that took me probably 15 minutes. I've already done a quick review, and that took me no more than 10 minutes. So I think it's important that you keep that as a living document that can change as you become more aware, as you amend your practices, and as people come to you and ask you questions and perhaps want to be added or removed from any membership list that you might keep. So that's the end of this presentation. I hope that you have found this useful. If you did have any questions, then you are very welcome to email me. My email address is julie.goucher@one-name.org. If you wish me to look over your privacy statement or give you any advice and guidance, I'm more than happy to do that in the spirit of one genealogist to another. Other than that, I hope if you attended the seminar in Odeby that you enjoyed your day, and if you did not, I hope you found this useful. And if you are interested in hearing a much longer presentation, then please do drop me a note. Many thanks for your time. Bye bye.